Restorative justice is a movement that goes way back to the 1970s. And during the early years of the restorative justice movement, it was focused very much on the juvenile justice system, young offenders, and primarily on crimes of pretty minor nature. Property offenses, low-level property offenses, very minor assaults. And the truth is, even to this date, many decades later, thousands and thousands and thousands of restorative justice cases coming through court systems still are primarily nonviolent and minor assaults. However, we began realizing, even toward the late 1980s, that there was a real need far beyond that. And it wasn't because of our thoughts. It was because survivors, those who had been harmed by crime, family survivors of homicide and other related serious crimes, sometimes sexual assault victims, would come to us and say, this sounds like a good program, restorative justice, or it used to even be called victim offender reconciliation in the old days. But what about me? You know, my son was murdered, or my parents were. And from the moment it's happened, I've wanted to meet the person who committed the offense, who was typically in prison at that point. And so that set in motion a process of responding to those request needs by family survivors of homicide and other severe offenses. And that began as a very small little effort. When I did the first such case in the state of Minnesota, that was in the early 90s, around 1991, I believe it was. No jurisdiction anywhere in the United States, anywhere in North America, anywhere in the world had formal protocol or administrative law or Department of Corrections policy that allowed victims of severe violence, survivors of homicide victims, those who had been harmed the deepest, to meet the perpetrator, the person who caused the harm, if the person who caused the harm was willing to do that. It's absolutely all voluntary. That's absolutely key. And in the early 90s, there's just two initial states that actually brought this into public policy, administrative law. Two very conservative states, Texas and Ohio, both who happen to be death penalty states. And those programs still operate to this date. Today, there's more than 37 states that have formal protocol, and working with very severe violent cases, including homicide, is in far more states than that, even though it's not always in formal administrative law. Now, what I'd like to speak to today is the gap between the large volume of very minor property offenses, very minor assaults, and the other extreme of responding to homicide survivors or victims of sexual assault. Because there's this whole area of court-referred, more serious and violent cases. We even began seeing that even decades ago, when occasionally a prosecutor would refer a negligent homicide case because he or she knew the survivors and the survivors of the person who died and knew the offender. And they heard the express need of those who were harmed to meet the person who killed their loved one through a drunk driving incident or whatever. So that was an early indicator that even at court-referred levels, there might be an appropriate use for victim-offender dialogue. Well, bringing that more up to current times, there are many, many jurisdictions where cases of attempted robbery, fighting that is quite serious, those are emerging in a variety of jurisdictions all over the country. And that's what I'd like to speak to today. I have a separate film that's available on YouTube called Working with Victim Offender Dialogue in Severe and Violent Cases, and that goes much deeper into what I just said a few comments. That also refers to some of the research I and colleagues did on this to see what the actual impact was on those who caused the harm and those who were harmed by such tremendous violence. But today I want to just highlight a few points on working with more serious cases through court referral, because the homicide cases, with rare exceptions, are referred through Department of Corrections years after the court system has dealt with the case. They're dealing with sometimes survivors, family survivors of homicide would come to me or others that I've trained over the years 5 years later, 8 years later, sometimes 32 years later or longer. But in court-referred cases, those are more likely to occur during the court process within a year or two. And again, that's what I want to speak to. It is extremely important to realize the impact of trauma. Trauma can occur in even the most minor offense, depending on the situation and the person involved. But particularly when you start looking at court-referred cases that are more serious, more violent, armed robbery, whatever, it is extremely important to have in mind trauma-informed care. And I want to highlight 5 key points. And this applies to so many other cases, but particularly in terms of what I'm addressing today. First is safety. Always be aware of the physical and emotional safety. Always be mindful of that. Don't get so caught up in what you should do and what you're thinking up here, but always be focused on the safety. And that relates to a number of other points I'll be addressing. Second point, trustworthiness. That people develop trust in you and the process. And that leads to the third point, which is absolutely central, choice. In fact, I'd say choice, 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 and more choice. Choice on even the most smallest items. Choices on whether you want to participate. Choices on where you want to meet during the preparation process or the actual dialogue. Choice on whether you want a support person present. Choice if they really would feel comfortable having some water available or tea available. I mean, little simple things like that. The more choice you give to people who have been traumatized, frankly, in any situation, not just what I'm talking about, the more people feel safe and the more they feel empowered. And that's one of the main points too, is empowerment. This is about sharing decision-making with the people who are requesting your assistance. And it's even more than that. That relates to the fifth and final point, and that is collaboration. This is a collaborative project between you and the people who have sought your services, working with both the person who had caused the harm as well as the person who was harmed deeply by the violence or more serious crime. It's collaborative. It's totally getting out of the mindset of, I'm the trained professional or volunteer, and I totally understand this, and I've read the research, and therefore I know this would be best for you. And there are some restorative justice practitioners, frankly, that operate that out of good intent. But there are many restorative justice practitioners who would say, well, what you really need is a victim offender mediation or a circle, like many, many today in the movement would say, oh, what you absolutely need is a circle. It must be a circle. And I'm here to tell you that that is not consistent with giving people choice. Making the whole process be informed by the reality of trauma and its impact on our lives and changing our whole perspective of our lives, our meaning of lives, how we're being, how our well-being is. That's all based on adapting the process to the people and their culture. If people want supportive family members, even neighbors present, I would check that out with the other parties involved, so all feel safe with that. And if that was the choice, I would honor that. And I prefer working in a circle format. On the other hand, my experience over the decades and my research has found clearly that there are many, many individuals, particularly in Western society, that really feel safer with a small group or even a one-on-one dialogue. And after having the one-on-one dialogue in a more serious or violent case, they then feel oftentimes more comfortable to enlarge the circle, to then invite other people that have been affected by the crime. And the last point I want to end on, and this is central to any kind of restorative justice dialogue, whether it's victim offender conferencing, victim offender mediation, those are basically the same. Family group conferencing, circles are called many things, peacemaking circles, talking circles, healing circles, and circles really are what we have learned and been gifted from the indigenous people of our land that have taught us. No matter what process is involved, there's one key process point that is supremely important. In fact, I call it the 3 most important elements of deep restorative dialogue: preparation, preparation, and preparation. Preparation of ourselves, to be mindful of our own energy, to tame our egos, to slow down, to still our minds, to get out of that mindset of we're the experts and we know how to help you. So it's preparation of ourselves. It's preparation of the parties before ever bringing them together, and only bringing them together if they want to, and also making it clear you can agree to come together and you have the absolute right and opportunity to exit at any point. If you want to cancel it, if you want to come to the meeting and leave early, that's your choice. And what I found over the years, the more you give people a choice to exit or leave, the more safe they feel, the more likely they are to enter the process. And then finally, preparation right before the actual dialogue, not just in the preparation process separately, but if they all want to actually meet, preparing yourself as a facilitator to tame your mind, your ego, to slow down, to be fully present with these people, to honor their strength and their wisdom. So there's much more I could say, but I think that captures the key points of moving from working with very minor cases to more serious cases that are court referred.